Silent put. Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Sofea and this is my teammate. We will present about business law, which is discharge of contract and remedies of contract. So this is my teammate Nurul Ezzah and Putri Nur Shariena. So I will present about discharge of contract. Discharge of contract refers to the act of bringing an end to or ending a contract. The definition is when a contract is brought to an end, dissolved or terminated, the parties are no more liable under the contract. It means that the contract has come to an end. So the parties to an agreement are freed from their contractual obligations. Discharge means when one or both parties to a contract are freed from their contractual obligations. So termination of the contractual relationship between parties is when the rights and obligations created by it come to an end. So discharge of contract have four, which is discharge by performance. Which is discharge by performance, and the parties to the contract performs the duties completely, and the performance must be accurate and exacting and in line with the parties' agreement. Second is discharge by agreement, which is the original contract will not have to be completed if the parties agree to replace it with a new contract or to resign or change it. Third is discharge by frustration. A contract is frustrated as the circumstance change making it technically or physically difficult to execute the contract. Fourth is discharge by breach of contract. When one of the parties fails to perform his obligation, indicates to the other party intention not to go on with the contract, the party is said to repudiate the contract. So I will explain about discharge by performance. So discharge by performance is usual method for the discharge of a contract. This is parties to the contract perform the duties completely, and the performance must be exact and precise and in accordance with the terms of the contract. So discharge by performance by section 38, discharge by performance, obligation of a party to a contract. The parties to a contract must either perform or offer to perform their respective promises unless the performance is dispensed with or excuses under this act or of any other law. So when the parties had carried out exactly what they have undertaken to do, there is a complete discharge. But if only one party performs his part of the bargain, he alone will be discharged. So elements of performance is exact, precise, in accordance with what the parties have promised. Performance may come from a third party, which is section 42. Performance from third party effect of a certain performance from third party. So when a promisee accepts performance of the promise from a third person, he cannot afterward enforce it against the promisor. So I will explain about discharge by agreement. Discharge by agreement is the parties themselves can agree to end the contract, form a new contract or vary the original one. If parties of the contract agree to substitute a new contract for it or to resign or alter it, the original contract need to be performed. For example, waiver, release, novation, remission or rescission. So, for example, waiver is a process of giving up any right or on anything with a voluntary action or non-action. Waiver of a right can be temporary or permanent nature. For example, if rent is waived for 1 month by refusing to accept, it does not mean rent is waived forever. Where a settlement is accepted and document exchanged as token, the waiver can be permanent. Next is release. It freeing from from an obligation or commitment, or liberating one from a duty or claim that she could have been held legally liable for. Third is novation, the substitution of a new contract for an earlier one, particular a contract between a creditor, a debtor and a third party, whereby they agree to substitute a third party for the debtor or creditor under the original contract, which will be discharged. Remission is discharge or release from penalty or obligation. Rescission is the destruction or annulling of a contract, determination of a contract unilaterally by a party for substantive legal reasons, such as the failure of the party to perform its obligation or the mutual termination of the contract, with the result both parties are restored. Second is available when fraud or mistake the rest or failure of consideration is present. So Section 63 of Contract Act, if the parties to a contract agree to substitute a new contract for it, or to rescind or alter the original contract, need to be performed. So, for example, A owes B $10,000. A enters to an arrangement with B and gives mortgage of his estate for 5,000 in place of that 10,000 ringgit, is a new contract and extinguish the old. So, I will proceed to Putri Nur Shariena.
So next is discharge by frustration. A contract is frustration when there is change in the circumstances which is renders the contract legally or physically impossible of performance. We look to Section 57(1) of Contract Act 1950. An agreement to do an act impossible in itself is void. Next slide. There are four circumstances of impossibility of performance. The first one is destruction of a subject matter of a contract, which means when a contract depends on the existence of that thing, but the thing was destroyed. For the case Taylor versus Caldwell, where the music hall was accidentally burnt down before the date of the concert. The second circumstances is where a contract depends on the happening of a certain event. In the event, if the event does not occur, the contract is discharged by frustration. Example case is Krell versus Henry. A room was hired for the sole purpose of watching the coronation procession of king was cancelled because of the king's illness. The third circumstances is supervening illegality, when the contract becomes illegal. The example case is Bernie versus Tronoh Mines Ltd. Japan invaded Malaya, therefore the contract of employment was discharged. The last circumstances is death or personal incapacity, where the contract is discharged on the death or incapacity or illness of a person if the performance of a contract depends on his personal skill and ability. Example case is Condor versus the Baron Knight Ltd. Drummer who employed was ill and not fit to perform, so the contract was discharged. So now we move to the last one, is discharged by breach. When one of the parties fails to perform his obligations, indicates to other party an intention not to go on with the contract, the party is said to be repudiated the contract. Their disability to perform is due to the fault of the party consents. There are three forms of breach. The first one is refuse to perform. Second is disable himself from performing promise. And the last one is repudiated liability under contract. So effect of breach. An innocent party may put an end to the contract and must restore any benefit which he may receive from the other party. We look to Section 65 of Contract Act 1950. Now we go to remedies for breach of contract. Means a right that can be claimed by a party to a contract that experienced losses because other party to the contract was in breach. There are four types of remedies. The first one is damage, quantum merit, specific performance, and the last one is injunction. For damage, The definition is the court's estimated compensation in money for detriment or injury sustained by the plaintiff in contract or tort. We look into Section 74 of Contract Act 1950. An injured party is entitled to natural damage, which means damage arising naturally and directly out of the breach in usual course of things. The second is special damages. Special damage are those which are indirect results of an injury which do not necessarily result from such an injury, such as medical bills, repairs and replacement of property, loss of wages, and other damage. Special damages are also called as consequential damage. So, aim of rewarding damage to give relief to the innocent party for the losses incurred, not to punish the party who is in breach. So, the last one is damages of unspecific amount, divided into three types. The first type is substantive. A reward given is to put plaintiff in the place that he should if defendant performed the contractual obligation. The second type is nominal. A small reward plaintiff after he shows that there is a breach of contract even though there is no losses incurred. The last type is exemplary. A reward given is far higher than the losses incurred. So now we move to Nurul Ezzah.
So next I will share about the quantum merit. It means payment in proportion to the amount of labor done. Generally, one cannot claim performance from another unless one has performed his obligation fully. But in certain cases, an individual who performs some work under a contract can claim remuneration for the work which he has already done. The right to assert on quantum merit doesn't arise out of contract as right to work does. It's a claim on quasi-contractual obligation which is implied by circumstances. The claim for quantum merit arises only when the true contract is discharged. When a party has, in performance of his contract, done some work or rendered some service, and therefore the further performance has been made useless by the opposite party, he may recover reasonable compensation for the work or service. Cases of quantum merit arise when there is no verbal or written contract, but it is understood that one should get what he deserves. According to Section 71 of the Contract Act 1950, where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoy the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered. As in the case example, for instance, consideration of the High Court decision of Muhammad Hamid Marichan bin Abdul Qadir Marichan versus Abdul Razak bin Hussein and Ors, 2010. In case, the one and only letter that supports the plaintiff claim for quantum merit expressly say that the balance fees are payable upon successful completion of the sale and purchase. Thus, despite the fact that the plaintiff had expended time and energy to get the required approval, as long that the share sales agreement itself wasn't completed, it couldn't be said that the plaintiff had accomplished what he was alleged to do to warrant payment. It must be manifest that the party on the receiving end of service had benefited from an equivalent. The third one is the specific performance. Specific performance is a discretionary remedy that is granted by the court and is under the Specific Relief Act of 1950. It is a decree by the court to compel a party from performing his contractual obligation, normally only ordered where damage doesn't seem to be an adequate remedy. It's a general rule that specific performance would not be ordered if the contract requires performance or constant supervision over a period of time, and also the obligation within the contract are clearly defined. Specific performance is usually ordered in regarding to building contract because the contract deals with result instead of the carrying on of an activity over a period of time interval, and it also defines the work to be completed with certainty. These are the conditions that the specific performance is not granted. In Section 20 of Special Relief Act 1950, given the specific performance will not be granted if contract involves on the personal qualification of a party. Second, there is a delay of time in bringing the action. Third, contract involves many minutes of numerous details. Fourth, terms of the contract are thus not certain. Fifth, money damage are an adequate relief. And sixth, there is an evidence of fraud. Lastly, it is injunction. Injunction is assessed under Part 3 of the Specific Relief Act 1950 as preventive relief. It is an equitable remedy and thus only granted at the discretion of the court. It's awarded in circumstances where damages won't be an adequate remedy to compensate the claimant because the claimant has to restrain the defendant from starting or continuing a breach of a negative contractual, undertaking a prohibitory injunction, or as to compel performance of a positive contractual obligation, mandatory injunction. An injunction won't be granted if its effect would be to compel a party to try and do something which he couldn't have been ordered to try to do by an order or specific performance. And this is the type of injunction. In Section 50 of Specific Relief Act 1950, preventive relief is granted at the discretion of the court by injunction, temporary or perpetual. So, temporary injunction is granted at any point during the suit for a specific time interval or as adjudged by the court. And for perpetual injunction, or it is as permanent injunction, it is granted after the examination of the facts and merits of the case by the order of the court. This is all from us.
Okay, that's all from our team about explaining about discharge of contract and remedies of contract.